When the law is right, but justice still fails. Structural failure in modern legal systems. What happens when every authority acts legally and justice still fails? How can rights be formally recognized, procedures properly followed, institutional responsibilities carefully distributed, and still no effective outcome be produced? This paradox does not reveal an absence of law. It reveals a limitation in how law sometimes understands its own function. Comparative legal theory offers an important insight. As legal specialists categories and argues, law cannot be understood as a closed and self-referential system. If law looks only inward at doctrine, categories, procedures, it risks detaching itself from the social reality it is meant to regulate. Law is not merely a collection of rules, it is also a social and cultural construct, and that distinction matters because some failures do not arise from missing rights, but from legal structures that are too narrow to absorb certain realities. Consider a case involving multiple jurisdictions: family law in one country, civil registration in another, nationality law in a third. Each authority applies its own law correctly. Each decision may be legally justified, and yet no solution emerges. That is not a doctrinal failure, it is structural failure. And this is crucial. The problem is not necessarily wrong decisions. The problem may be that legally correct decisions do not connect into a coherent result. That is a very different problem. Imagine a child caught between family law, citizenship law, migration law. Each institution sees only its own part, but no institution sees the whole. And when nobody can address the whole case, the legal system can become procedurally correct and substantively ineffective at the same time. That is the paradox. This is why comparative law matters, not to rank legal systems as better or worse, but to reveal their limits. Different systems reflect historical development, institutional culture, social assumptions, and a system that functions well under ordinary conditions may prove insufficient when confronted with situations outside its structural design. Comparative law does not merely compare solutions, it exposes blind spots, and sometimes those blind spots matter more than the rules themselves. Traditional legal systems resolve disputes inside categories: civil, administrative, criminal, but some cases exist between categories, and there, responsibility fragments, coordination substitutes for responsibility, protection becomes theoretical, rights may exist on paper, yet no mechanism exists to integrate them into an outcome. That is where structural failure begins. This is not a critique of individual officials, not an accusation against courts, not even a rejection of legal reasoning. It is a recognition that legal systems, however sophisticated, may encounter limits built into their own architecture. And recognizing those limits is not hostility toward law, it is fidelity to law, because serious legal thought does not end where systems become uncomfortable, it begins there. And this leads to a larger question. If some exceptional cases exceed the structure of ordinary procedures, should legal systems develop exceptional mechanisms to address them? That is a question I will explore in future videos, because the question is no longer whether these cases exist, the question is whether law is prepared to adapt to them. Thank you for watching. If this perspective interests you, subscribe to the channel and visit law-clinic.eu.